So let's talk about one of the most powerful and honestly most complicated ideas in family law, the best interest of the child standard. It's supposed to be this guiding light for the courts. But what happens when that light seems to lead a family into a very, very dark place? We're going to dig into that today through a case out of North Carolina that really puts this whole standard on trial.
Okay, so in North Carolina, the law is pretty poetic about this. It calls the best interest of the child the polar star. That's a big deal. It means this one single idea is supposed to be the ultimate compass for a judge in every single decision they make about a child's life, their safety, their future, and yeah, even their parents' rights. The whole idea is that the child's well being has to come first, above everything else. It's a really powerful ideal, right? But in the real world, trying to apply this standard can get incredibly messy. For one family in North Carolina, it felt a whole lot less like following a guiding star and a lot more like getting pulled into a legal black hole. So first things first, let's break down what this best interest standard actually means. And we're going to use the North Carolina case of In Re MB as our guide, because this case puts the entire concept right under the microscope. And this is really the key thing to get. Best interest is not some simple checklist. The law is super clear that this can't be a one-size-fits-all formula. It absolutely requires a deep, comprehensive look at each child's unique, individual situation. It's this incredibly complex balancing act. A judge has to weigh literally everything. We're talking about a child's welfare in the widest possible sense: their physical safety, their emotional health, their social life, their connections to their home, their school, their whole community. And of course, they look at the parents' conduct. And if the child is old enough to have a say, they listen to their wishes too. All right, let's dive into the specifics of MRE, MB. This is where all those abstract legal ideas we just talked about crash right into the real-world story of a family in crisis. So here's how it all went down, and it happened fast. The case kicks off in late 2023. On November 6th, the Department of Social Services, that's DSS, files a petition. Then, just over a month later, on December 19th, the court takes this incredibly drastic step. It orders the mother, Kelly O'Neill, to have zero contact with her daughter, Mara. None. And that no contact order is right at the very heart of this story. Okay, before we go any further, let's get a handle on who's who in this story. At the absolute center, we have the child, Mara. We've got her mother, Kelly O'Neill, and her father, Michael Bridges. And then you have the official players, the government agency, DSS, a guardian ad litem who's appointed to be the child's voice in court, and of course, the judge, who holds all the power. And this is where things take a really critical turn. A central issue in this case quickly became the mother's mental health. This pivot raises some huge questions about how our legal system deals with disability and whether the laws meant to prevent discrimination are actually working inside the courtroom. Now, you'd think there would be protections for this, right? And there are. Federal law, specifically the Americans with Disabilities Act, the ADA, is supposed to be a safeguard here. It's super clear. You cannot make life-altering decisions based on stereotypes or just a diagnosis alone. The law demands a fact-specific, individualized look into a person's actual situation and abilities. And this is where the conflict just becomes crystal clear. On one side, you have what the ADA requires: individual inquiry, objective facts, using the least restrictive options. But on the other side, you have the allegations in this case: a hyper-focus on a diagnosis, a reliance on stereotypes, and a process that just felt punitive. I mean, the contrast it's just stark. Okay, now we get to the absolute core of the legal appeal. The argument is that this indefinite no-contact order wasn't just a restriction. It was, for all intents and purposes, a termination of parental rights, but one that completely bypassed all the required constitutional protections. So what is a formal termination of parental rights, or TPR? Well, think of it this way. It's the legal equivalent of the death penalty for a family relationship. It permanently and irrevocably cuts the legal bond between a parent and child. And because the stakes are that high, the law sets an incredibly high bar for the state to do it. And here's the crucial legal difference. To formally terminate parental rights, the state has to prove its case with clear, cogent, and convincing evidence. That basically means the evidence has to be rock solid. It's a much higher bar to clear than just saying something is more likely than not. But here's the problem. The no contact order was issued using that much lower, much vaguer, best interest of the child standard. The state never had to meet that higher constitutional burden of proof. So the bottom line of the appeal is this. By putting an indefinite total ban on all contact, the court basically achieved the same result as a TPR, but without having to do the hard legal work the Constitution demands. It was a termination in everything but name, what lawyers call a de facto termination. And all of this really boils down to one of the most fundamental ideas in our legal system, due process. The appeal in this case isn't just about the final decision, it's about whether the mother ever got a fundamentally fair chance to fight for her child in the first place. So what is procedural due process? Well, you can think of it as a constitutional promise. It says the government cannot take away a fundamental right, and parenting is one of the most fundamental rights there is, without giving you proper notice of what's going on and a real meaningful chance to tell your side of the story. And the appeal points to a whole laundry list of alleged failures here. We're talking about court orders that were vague, even contradictory. Critical reports were mentioned in court orders, but were never actually attached. I mean, imagine being told you have to follow the rules, but nobody will show you the rule book. It left the parent completely in the dark. On top of that, there was an alleged communication blackout from DSS and claims that her legal counsel was ineffective. Altogether, it paints a picture of a system where it feels impossible to get a fair fight. And look, while the details of INRI MB are specific to this one family, they really point to much bigger systemic challenges. This case isn't just about one family. It's a window that puts the entire child welfare system on trial, revealing some serious cracks that affect families all across North Carolina. And here's a number that might just stop you in your tracks. The state's child welfare system is facing staffing shortages of, get this, 25 to 40%. When a system is that strained, that overworked, you can start to see how shortcuts might start to look tempting. Shortcuts like an indefinite no-contact order, instead of the much tougher legal process required for a proper termination of rights. Now, it's not like nobody's noticed these problems. Lawmakers have passed reforms like Ryland's Law and the Fostering Care and NC Act to try and fix things, to get better oversight and stronger due process. But, passing a law and actually changing a huge under-resourced system are two very different things. The sources say implementation has been painfully slow, and for the families caught in the system right now, that change just isn't happening fast enough. Which leaves us all with this massive, fundamental question. How does a system, especially one that's under so much pressure, strike the right balance? How does it protect a child from harm while also fiercely protecting a parent's constitutional rights, especially when the powerful and often unfair weight of stigma walks right into the courtroom? It's the central challenge, and one that cases like this force all of us to confront.